So you should see a pop-up on your screen to give us permission to be able to record this. We will be recording the session and having it available both on the convictionreview.net website, which we have set up, and of course on our YouTube page. So I want to welcome everybody to a monthly meeting for CIU and Innocence Organization staff members. This, of course, is funded by a grant from the Bureau of Justice Administration under the Upholding the Rule of Law and Wrongful Convictions Review Program. My name is Marissa Bluestein. I'm an assistant director at the Quattrone Center for the Fair Administration of Justice. We're a national TTA provider under the grant. I need to introduce my colleague, Kia Hayes, who I think has just gone dark over there. But for those of you who don't know her, Kia has just recently joined the center and is working with us on this grant. So she will be a part of these meetings and of course doing one-on-one consultations as we go forward. So want to give notice about the next couple meetings. We meet on the second Wednesday of the month from 2 to 3:15 over Zoom. The next month in January, we actually will have folks from the New York Law School, Post-Conviction Innocent Clinic, and the Suffolk County, New York District Attorney's Conviction Integrity Bureau. They're going to be talking to us about an audit that was performed on cases involving a particular homicide after an appellate court decision came down notifying that there had been misconduct on a prior case. They actually reviewed all the cases that prosecutor had been involved in, took action on one case, provided information on others, but they're going to talk to us about that process and what came out of it and what changes are being made at the DAO because of that. And then in February, by popular demand, we are bringing back the folks from Healing Justice. So Healing Justice, as most of you know, is an organization that works with victims in post-conviction investigations to help them through their re-traumatization and avoid other issues. They also work with restorative justice measures to bring in exonerees and victims together to help heal. They'll be coming back to talk with prosecutors in particular and defense lawyers about working with victims in a post-conviction world. What are the best practices, how you can be adjusting your policies to be able to ensure no further victimization and re-traumatization for folks who were the original victims of the crime. So we're looking forward to those coming up. And as always, if anybody has questions or things you want to have more training on, please let us know. We're happy to put that together for future meetings. So with all of that, I'm just so thrilled that Alyssa Hadari from the Institute for Innovation and Prosecution can be joining us today. The Institute put out a report several months ago, which has been forwarded to everybody already, on tracking police misconduct and ways that prosecutors can be ensuring their ethical duties of tracking police misconduct, making that available, and when to and how to put that together. So Alyssa's going to be talking to us about that project and what the best practices are. The Institute is, of course, at John Jay College, and we use a lot of their resources in the work that we do here with conviction integrity units and innocence organizations. And so, Alyssa, we're so grateful to have you. I'm going to go ahead and stop my share here so you can take over.
Great. Well, thank you, Marissa and the Quattrone Center for having me. I've been looking forward to this presentation for several months now. I see a lot of new faces, so nice to meet all of you who I've not interacted with. And for those of you I do know, it's great to see you all again. I was thinking before I do anything, I was wondering if everyone can sort of just raise their hand, little icon, if you are a prosecutor in a conviction review unit or a conviction integrity unit, just so I know who the audience is. Okay. Or yeah, you could just also raise your physical hand on camera if that's easier.
Or applaud. Thanks, Matt.
Okay, and then if I could, thank you, you can put your hand or thumbs up down. And if you could do the same now if you're an innocence attorney or defense attorney, just again, so I know who the audience is. So I guess it's roughly half and half. Okay, great. So yeah, I'm used to speaking more to prosecutors, but I'm going to try to keep that in mind. I think today, I'm going to briefly introduce myself, the IIP, for those of you who aren't familiar with our organization, was going to outline the reasons why, in our view, every prosecutor's office, no matter how small, no matter how big, should have some form of a Brady list, or they're known as Gilio list, do not call list, police disclosure list. And then the last part I was thinking we could discuss is the recommendations that we make in our Tracking Police Misconduct Guide. It's interesting because there's no real right way to do this. Frankly, I think that the number of prosecutors' offices that even have a Brady list is too small. So I frankly applaud anyone who has a list to begin with, because those offices are ahead most of the other offices that we have spoken to. But there are some common denominators in terms of things that prosecutors should at least think about when putting together these lists and maintaining them and figuring out what the office protocols are going to be surrounding these databases. So first, in terms of introducing myself, just so you know a little bit about my background, I was a line prosecutor for several years at the New York County District Attorney's Office. I was in the trial division, so dealing with, kind of typical line prosecutor work. Started off with misdemeanors, graduated to felonies, everything from low-level assault and driving while intoxicated cases, and then eventually, of course, homicides. And then I joined the IIP about over a year ago, which, as Marissa said, is based in John Jay College here in New York City. So I'm going to share my screen just to talk a little bit about the IIP very briefly. And let's see here. All right. And if you want, you can lower your hand unless you're actually asking a question. But yeah, I just wanted to get a sense of who is in the audience. So the IIP is...
And just while Alyssa's getting that up, just want to know if you do have questions as we go along, I'm sure Alyssa would be more than happy to hear them. You can feel free to just put it in the general chat or chat it to me or raise your hand and we'll keep an eye out for you.
Yes. And Marissa, it might be hard for me to do the chat at the same time, so just interrupt me if there's a bunch of questions that I'm completely missing. So the IIP, we're a national organization. We bring together prosecutors, policy experts, defense attorneys, academics, directly impacted people, both people who've survived crime or been victims of a crime, as well as those who've been formerly incarcerated. Obviously, those people can often be all in one person. And we have these convenings to promote, frankly, reform-minded practices in prosecutors' offices. So out of these convenings, we'll put together best practice guides, webinars, and training materials that prosecutors can use. And we are based in New York City, but we really are a national organization that engages with DAs from very large jurisdictions, such as Chicago, New York, San Francisco. But we also have been working with a lot of DAs from much, much smaller, more rural, sometimes conservative jurisdictions as well. And let's see, the process. So I figured I would talk to you all about the process of what it was to put together this Tracking Police Misconduct guide. This isn't something that sort of the IIP just put out there based on what we thought are best practices. This document is the result of conversations that we had with either the elected DA or people relatively high up. Some of them were heads of conviction review units, such as Patricia Cummings from Philadelphia, and basically asked them questions about, why do they have a list? What was the process in putting it together? What were some of the challenges that they faced? And the offices that we interviewed were very diverse, both in size and jurisdiction. So we interviewed people in King County, Washington, Maricopa, Arizona, Bernalillo, New Mexico, and then a couple of people in our Beyond Big Cities initiative group, which are DAs from, many of which are from smaller, much more conservative and rural jurisdictions, just to get as broad a perspective as we could on what different DAs are doing when it comes to these Brady lists. And then in addition to that, we got input from members on our advisory board, and those include people like Fox in Chicago, Paul Butler, who you probably all are familiar with, a law professor at Georgetown. And so really tried to get as broad swath of input as we could, particularly from prosecutors. Although we did also speak to somebody in the NADCL just for their thoughts on Brady lists. And I know that they're putting together their own national database, which we'll get to that in a few minutes. So that's what the process was in putting together this. So I don't know if anybody else heard that, but there's something about recording. So that's what the process was in putting together this guide. I have a feeling that given this group, I'm kind of preaching to the choir as to why prosecutors' offices should have a Brady list, but I'm going to just sort of go through them anyway, just so that we're all sort of starting on the same page. So there are several reasons why. I think the first reason that we always talk about is it's to help prosecutors comply with the law. Everybody in this room knows prosecutors have an ethical and legal obligation to turn over exculpatory information about their cases. And the Supreme Court has extended that concept to include impeachment material about testifying witnesses. The woman that is depicted here is Deborah Milkey. She was prosecuted in Maricopa County in Arizona several decades ago. She was convicted of murdering her 4-year-old son and was sentenced to death, and she spent many years on death row. And the Ninth Circuit Court of Appeals came out with an opinion, I believe it was in 2013, essentially making findings that there had been extensive Brady violations, and as a result, essentially overturned Ms. Milkey's conviction. And the entire case against Ms. Milkey hinged on a confession, and there was no recording of the confession. There was also no direct evidence or witnesses other than the confession linking Ms. Milkey to the crime, to the murder of her 4-year-old son. So obviously the confession was critical. And it turns out that the Ninth Circuit determined that the detective on the case, Armando Saldate, had a long history of misconduct. You know, just as a couple examples, he had a 5-day suspension for taking liberties, as they put it, with a female motorist who he pulled over and then lying to superiors about it. He had multiple confessions or indictments that were tossed out by judges because Detective Saldate had lied under oath. And there was this long history where essentially the Ninth Circuit determined that the prosecutor on Ms. Milkey's case either knew or should have known, because all of these cases happened within the same county, with the same detective, should have known about this Brady information and failed to disclose it. My goal in using Ms. Milkey's example is not necessarily to criticize Maricopa County's DA's office. I don't know if there's anybody here from that county attorney's office. The reason I'm bringing this up is because, you know, either the lesson learned from here is either, you know, Ms. Milkey was wrongfully convicted and was innocent and spent many years on death row, or, you know, the most generous way to look at it is even if she was guilty, you now had a conviction that was being tossed, and you know, a defendant was being freed because there had been a failure by the prosecutors to track this misconduct. And the most important lesson from this case is that any information that is known to a prosecutor within an office is imputed to another. So even if the person handling Ms. Milkey's case didn't know personally about the misconduct of his detective, it was on the office as an institution, as an agency, to make sure that every line prosecutor in that office was aware of this detective's misconduct. Because they didn't track it and because they didn't turn it over, her conviction was tossed. So the number one reason essentially to have a Brady list is to ensure that your prosecutors are complying with the law and are able to comply with the law and have that information available. The second reason why a prosecutor's office should have some kind of tracking mechanism or database is prosecutors need to know the quality of their own evidence. I mean, I was a line prosecutor and I would have always wanted to know if I had a main key witness with some credibility issues, you know, whether it's a civilian or a police officer, if it's a criminal conviction or a history of lying or bias. Those are things that prosecutors need to know. And obviously, especially in the huge offices, prosecutors can't possibly know the history of every single officer on their own. So it's on the office to maintain that information and figure out a way to disseminate it to all the line ADAs or all the line prosecutors in their office. The third reason why it's critical to have a Brady list is defense attorneys are compiling their own lists. So putting aside legal requirements, ethical obligations, you know, the desire to know your evidence is strategic. You know, we don't want prosecutors in a situation where they have a direct examination of their police officer And then the defense attorney is cross-examining them and brings up all this information that the prosecutor wasn't aware of. The National Association of Criminal Defense Lawyers has been in the process of putting together their own database. They understandably, they weren't able to tell me much about it because it's not public yet. But I think from a strategic standpoint, at a minimum, it is really important for prosecutors to be tracking this information, particularly because defense attorneys and public defense organizations are starting to do their own. So the Cop Accountability Project was something that was spearheaded by the New York City Legal Aid Society. I remember when this came out when I was a line prosecutor, it was a big deal because we learned that all the defense attorneys now had access to this database of civil lawsuits. I can't remember if there was information about disciplinary records, but also social media posts that police officers might have had that have been racially charged. And so again, defense attorneys are doing it, so prosecutors need to be doing it too, so they don't lose some kind of advantage during their cases. And then the last reason that we cite as a reason to have these Brady lists or these do not call lists is, especially in a post George Floyd environment, prosecutors really need to send a message that they're going to hold police accountable in order to foster public trust. And one way, there are many ways that prosecutors can do that, but one way they can do that is to have these databases make clear to their communities they're tracking their police officers' misconduct, and they have a way of ensuring that, number one, the prosecutors are aware of it, so that when they're evaluating their cases, they actually know the real strength of their cases, but then also, of course, that they're able to comply with their ethical obligations and turning that information over to the defense. So there are other reasons why you should have some kind of police disclosure list, but those are 4 of the biggest reasons that we determined after doing some research and, of course, speaking to a lot of these elected DAs. I'm going to go into the recommendations that are in the Tracking Police Misconduct Guide. Of course, you can read it at your leisure, but I thought maybe I would highlight the ones that had a lot of behind the scenes conversations with the prosecutors who we interviewed when putting this together. And the ones that I don't cover, it's not that they're not important, it's just I think they're a lot more straightforward. So the first one is get as much information as you can from police departments. Police departments are a wealth of information on their own officers, of course. They have disciplinary records. I say that understanding that every state is different. Every state is going to have different laws on privacy, or I should say on every state will have a different level of shielding police records, disciplinary records. So in New York, for the longest time, it was really difficult for anybody to get disciplinary records from police departments, including my old boss, Cy Vance. They repealed that statute. I think it was sometime in the last year, but that is something that is a challenge to many prosecutors. And so one way that we learned that prosecutors are trying to get this information from their police departments is to create MOUs or memorandums of understanding with their local police chief. And this allows the prosecutor's office and the police departments and the sheriff's office to have a streamlined process by which law enforcement will just turn over certain disciplinary records to the prosecutor, to the prosecutor's office, and then the prosecutor's office will have a way of collecting the information and disseminating it, rather than having line prosecutors every time they get a case now trying to get information on an ad hoc basis from the police department about their officers. One thing I wanted to flag is, of course, not every prosecutor's office has a great relationship with their counterparts in the police department. But for those of you who do have a good relationship there, like I said, the MOU is a really great way to get that information in a systematic way. And on our website, along with the Tracking Police Misconduct Guide, is an appendix. And in the appendix are sample MOUs that were signed by a couple DAs who we interviewed along with their police chiefs. So rather than reinventing the wheel and having to create an MOU from scratch, I encourage you to look at those and just borrow from them rather than having to reinvent the wheel and write your own MOU. One other example separate from the MOU that we found was in Albuquerque. The elected DA there is Raul Torres, and they have a very unique process where the prosecutor, the line prosecutor, for every case, when they have a testifying officer, will interview the police officer, have them fill out a questionnaire about prior misconduct. And if the officer says, no, I don't have any prior misconduct in this, and answers no to all the questions, the line prosecutor actually still verifies with the officer, with the police department, as to whether or not those answers are true. And if the answer is yes, I have, for instance, been disciplined in this way, then it is on the line prosecutor to follow up with the police department and get more information about the context of that disciplinary infraction, for instance. So that was, I'm sure there might be other offices that do that, but that was one interesting approach where the DA's office had made it an office policy to have every line prosecutor for each officer interview that officer or have them fill out a questionnaire and get information directly from the police officer about their history, and then verify it with with the police agency. And in terms of what kind of information that prosecutors are collecting, most often from police departments, but sometimes other sources, are whether or not an officer has ever been convicted of a misdemeanor or a felony, whether or not an officer has had an incident where they misrepresented or failed to disclose a really important fact in a police report, incidents of bias. I think that often comes up in maybe sustained disciplinary infractions that a racial slur was used. Sometimes it comes up in the context of social media that the police department is made aware of. And then there's also been instances of altering or misusing evidence or mishandling evidence, just general incompetence. And so the types of information that different offices collect varies, but there's obviously a huge spectrum of what could constitute misconduct, and every office is going to have to essentially decide for themselves how broad they're going to go in systematically collecting this information. I thought, rather than just listening to me talk for an hour, maybe it would be interesting for all of you to discuss amongst yourselves, and then we can have a more facilitated conversation. So let's see what time it is. 2:26. So maybe for about 5 minutes, we can get into breakout groups. And what I wanted everyone to discuss is when it comes to police disciplinary records, some of them will just be pending and some of them will be sustained. Most of the offices we spoke to, probably actually all of the offices we spoke to, agreed if there's a sustained finding of a disciplinary infraction, that should be, if not disclosed, should at least be put on the office's Brady list. But one more controversial topic is, what do you do with pending disciplinary complaints in a police department? And so why don't we go into breakout groups, and we'll have maybe 1 or 2 or maybe 3 of these groups report back sort of what the discussion was in terms of, if you are in a prosecutor's office, what are you disclosing pending disciplinary complaints? And if you're not a prosecutor's office, what do you think prosecutors should do with regard to pending disciplinary complaints? So we'll see you all back here in about 5 minutes.
Okay, so you've all been asked to join a breakout room. Please go ahead and click join that room. If you have any trouble, I'll stay out here to make sure everybody gets placed. And you said 5 minutes, Alyssa, is that okay? Wow, okay.
All right, we'll wait for everybody to trickle back in. And I mean, I can tell you all what happened in my group, but would love to hear from somebody else, you know, what the different approaches were, either in the prosecutor's offices or, you know, if your office doesn't have a Brady list, what your thoughts are on whether to put pending disciplinary complaints on a list, and then whether or not from there to disclose it. So anyone who wants to raise their hand or just speak up would be great. We'll just take like 5 minutes to have a conversation.
I can speak before anybody raises their hand. Hi, it's Craig McKelvey.
Hello.
Hello, Group 8, representing Group 8. All right, Group 8. We discussed a few things. I mean, one of them was, I mentioned a list that we had, which included silly things like a police officer who left a radio on top of his cruiser and drove away with destroying the radio. I mean, that's the kind of thing that, who cares? I mean, how does that affect it? And they said it really has to do, and we discussed the intent of the officers involved. If they have a pending investigation and it's a misuse of power, somehow a misuse of power or misrepresentation of their authority, even if it's just a pending charge, it's probably something that you want to, as a prosecutor, you want to explore with them and possibly offer to the defense if you determine that's something that should be, sorry, my motion lights. If it's something that, you know, should be explored.
I don't know if it's just mine, but all of a sudden I wasn't able to hear Craig. Was it just me?
Can everyone hear me now?
I could hear him the whole time.
Are you all able to hear me?
Yep, Alyssa, you're good? Craig,
Yes.
you can hear you.
For some
Alyssa
reason, I
can
can't
hear
hear
us.
anything. Sorry.
Craig, can you just say that part again?
Just the last part. Sorry, I'm able to hear now. It was just the last part where you said.
Please call us at 800.
Okay. I mean, I don't have the script. I think I was talking about the misuse of power, misuse of authority that you would want to look into and discuss with your witness, as well as something that you might, depending on what you find out from that, share with the defense, and something that would be proper for them to explore, even if it was just a pending charge that was made by, especially if it was made by someone within the citizenry, where that information might otherwise be available to them.
Definitely, thank you. Anybody else? Either your office policy, or if you don't have an office policy, what you think it should be for pending disciplinary complaints. You know, also happy to hear from the innocence attorneys on the call too. Yes, Richard Davis.
Hi. So I guess I started our group talking from the innocence attorney perspective, which is why not just disclose everything, or at least start with a presumption, disclose everything, and then work out what there's not to disclose. I think a good point that I had before, I think was made, is that there may be a state law privacy law that governs what can be disclosed, and so well, that would of course be trumped if it actually was Brady material. If it's a pending complaint covered by a state privacy law and it's truly not favourable in the case, then obviously the prosecutor couldn't violate the state law to disclose it. So I think where we came down is that that's probably going to be a case-specific decision. And so what kind of makes sense is the prosecutor should have everything, but they're going to have to make an individualized decision depending on whether it is favourable in any case, because a pending complaint, depending on the conduct, may be favourable evidence to the defendant in one case, but not in another case if it's, you know, misconduct alleged, but might be similar to what might be the defendant's defence in a particular case. It could be 404B evidence. If it's a completely different kind of crime, and it's a pending complaint, it may have no favourable value. So, and then I think the other issue that was mentioned was if as a pending investigation, it might be jeopardised by public information, and whether you would need to consider that and potentially use protective orders so the defence had access to it, but it wasn't just available in a public court file.
Right. Yeah, I mean, I think that's, you raise a good point, which is technically there's two questions. One is, do you put the pending disciplinary complaints on the list, which is held internally? And then separately, do you then disclose that information? Because there is a world in which you put every single pending allegation on the list, but you only disclose some of it, right? So, you know, we just wanted to highlight a couple different office policies that we came across that we thought were interesting. And one of them, I mean, some offices just won't put anything that's pending on their list, and therefore they won't disclose it because their attitude, their viewpoint is, you know, this person hasn't been actually found of any, you know, guilty, so to speak, of any misconduct. And sometimes people file frivolous complaints against police officers, so we're not going to disclose that information, you know, until there's been a sustained finding or a criminal conviction or something similar. But Snohomish County, Washington, not sure if there's anybody on the call from that county, they will add somebody to the list who has a pending investigation if the investigation has been going on for 30 days beyond their customary target time for investigation. So essentially a pending investigation that's been going on longer than usual, which I thought was a really interesting policy. The benefit of that kind of policy is, you know, in the interest of transparency and, being, in an abundance of caution, you disclose that information, but they don't just sort of put any pending allegation on the list that's then disclosed, because trying to recognize, the rights of the police officers and the fact that some allegations might be frivolous. We also spoke to somebody who had said that in their office, they had a policy where if there is an allegation of serious misconduct, and now I don't know what serious misconduct means. I'm assuming it's, a horrific excessive force or some kind of blatant perjury, even if it's only pending, if it's serious, they would then ask a judge to review it in camera and then have the judge make the decision. So the point is there are a lot of different things you can do. My personal thought is to err on the side of disclosure, even when it's pending. But I say that, acknowledging that we have to, be cognizant of the rights of the officers as well. And to Richard's point, there might be state statutes that protect those records, which is another complicating factor. So we're going to move on from the pending investigations. I'm going to go back to sharing my screen. And let's see here. Let me just see. Okay. Another recommendation we had is to designate a person or a group of people responsible for deciding which officers are put on a police disclosure list, and then to determine the standard of proof. So, of course, if you're going to be systematically trying to create a list, you can't just have every prosecutor in the office collecting this information. You want to have one person sort of in charge of collecting it, and then one person or a group of people, particularly in a larger office, deciding who gets on the list. And we also don't want prosecutors sort of arbitrarily figuring out who's going to be added to a list. There should be some kind of standard of proof. So one common practice that we found, particularly among the bigger offices, is the creation of a so-called Brady committee. These committees often included, pretty senior prosecutors, often the head of the conviction review unit, who would collectively either decide or recommend to the elected whether or not someone should be added to the list. And in terms of the standard, we had several offices require a substantial information as standard of proof. So basically saying there needs to be substantial information that an allegation against an officer exists. Now, substantial information kind of varied among the offices, but one common theme we found was that, you don't just put an officer on a list based on a rumor or unverifiable hearsay or a conflict of testimony. There has to be something more than that. King County, Washington has a slightly different approach in that they sort of go out of their way to not be a clearinghouse for whether or not something should be added to the list. They basically say, for instance, if a line prosecutor becomes aware of potential official misconduct, maybe they determine that they're not sure if the officer is telling the truth because their story has changed drastically, rather than sort of investigating internally whether or not this person should now be added to the list, what they will do is they will forward this incident to an investigating agency, maybe it's internal affairs at a police department, and will only add the officer onto their Brady list if that outside agency sort of makes a sustained finding that there was some kind of misconduct. So in other words, they sort of avoid positioning themselves as the investigating agency or the clearinghouse as to whether or not someone has actually engaged in misconduct. So again, the whole purpose of this guide is really to get prosecutors who are going to create a protocol to think through all these different issues, because there are many different ways in handling it. It's going to vary based on state law and your office's culture. And let's see. Okay, so let's see how much time we have. I don't know if we have enough time to do another breakout group, so maybe we'll just discuss it here. But one question I wanted to ask everybody is, as we all know, Brady requires materiality in the sense that, generally speaking, the information has to be material in order for it to constitute as Brady. And so, but that being said, some offices say only if it's material misconduct will we put it on our Brady list and disclose it. Other offices go beyond that. So curious, just to hopefully have a quick facilitated conversation, for the prosecutors in the room, if you already have a policy, do you use a materiality standard, or do you put even the most minor misconduct on your lists? And for those of you who don't have a list, or for the innocence attorneys, would love your thoughts on, what their views are on what the best practice would be. Somebody's got to have a list on this call. Come on.
I'm looking down at Matt Howard. Matt, I'm pretty sure you guys have a Brady list in your office.
Yes, we do. And I said this in my breakout room a second ago. I am not the best person to speak to this because we have an ethical disclosure attorney who actually is reviewing the list every day and making additions as needed. But to sort of get to the question a little bit, I think as a general rule, we try to avoid materiality determinations as prosecutors. And so we, generally, not even inside the realm of officers necessarily, if there is a question of should we disclose this or is this material to the case, we feel like the bare minimum we can do is provide it to the court and say, we don't want to make the call here on materiality. Judge, please take a look at this and review this in camera. And if this is something that needs to be disclosed or made available to the defense, please let us know. We will happily do so as long as that determination is made by the court. Now, if one court has already determined that it's material, then we can kind of follow that throughout with that officer. But if that's, if it's kind of a matter of first impression for us, we're trying to figure out if this is something that we need to disclose on this officer, pending or otherwise, give it to the court, be safe about it.
Thanks, Matt, especially because we put you on the spot. Ashley, go ahead.
I don't want to, I'm not on the Brady committee, so I don't want to say something that isn't factual, but from when I was doing trials and stuff, it seems like everything is given to us. So if an officer is charged, we get that. So even if it's relevant or not relevant, I feel like our office kind of errs, like you said, on the side of, rather disclose than not disclose. And then now that I'm in the CIU, I feel like when I see the Brady notices, I feel like it is sometimes it's relevant, sometimes it's not. And I've learned that, or we as a unit have learned, like you can't really know what's going to be important until after the fact sometimes. Like I've had cases that were disclosed with Brady issues, and I guess at the time, maybe it may not have been material until like post-conviction matters start popping up and things like that. So I think that it's always best to disclose as much as you can. If you know it, like one thing that I was told during training was if you have to ask, then go with yes for now, go with disclose, and then you can reel it back rather than trying to put the information out later, because then it's worse, if that makes sense.
Which office are you with?
I'm with Orange County in Florida.
Yeah.
So we usually disclose. I know that I was telling my breakout room that we get everything. We get misconduct when it's charged, when it's not charged. Sometimes as far as the internal review, sometimes we don't always get those, but definitely for crimes, we get those. For
Right.
internal reviews, those tend to come to us in like different fashions of just, interviewing our officers, talking to defense, talking to the other officers or uppers. Sometimes they will tell us, they'll be like, just to let you know that this is currently pending, because they know that it can unravel the cases. And sometimes they have like a bid in the case themselves, especially when it comes to like the more egregious crimes.
Right.
So try to make sure that there's not really an issue later.
Yeah. No, thank you. Thank you so much, Ashley. Thank you, Matt. I think we're all kind of, I haven't had a chance. Let me ask first before I move on. Does anyone disagree? Does anyone actually feel that there should be a pretty, that offices should really stick to material, and maybe for whatever reason err on the side of, if it doesn't seem quite material on its face, then it should not be disclosed? Okay. I think the fourth recommendation we have is sort of rooted in sort of the conversations that both Matt and Ashley, or the thoughts that Matt and Ashley gave us, which is, our view is that if the policy states that only material information is going to be included, which is the case for some of these office policies, the policy should at least take an expansive view of what counts as a material disclosure. Some offices have actually gone beyond that, specifically in light of case law. So I think it was San Francisco, and there was one more county that I'm blanking on in California, where there's a Ninth Circuit case that basically says that prosecutors should disclose favorable information to the defense regardless of materiality. So particularly in light of that Ninth Circuit decision, one of the offices, again, I can't remember if it was San Francisco or a different one in the Bay Area, basically made a decision to say we're not going to have a materiality standard anymore. And I agree with what Ashley's saying, where in the moment it might not seem material, but that could easily change based on the facts of the case. And then, prosecutors often don't, I should say, very often don't look at cases the way a defense attorney would. So something that doesn't seem that important or that critical or material to me as a prosecutor might actually provide a great line of cross-examination or reasonable doubt for a jury in the eyes of a defense attorney. So we recommend that offices err on the side of, disclosing more, even if it's not clear that it's material information. Just a small example of that is, you could easily see a disciplinary infraction for failing to check the backseat of a patrol car before an officer takes it out on patrol as such a minor, unimportant infraction, right? We're not talking perjury or excessive use of force or racial bias. But my first trial as a prosecutor involved a person who was arrested with cocaine and he was arrested for something unrelated. And then when they got him to the precinct, they found cocaine in the back of the patrol car. little tiny container of cocaine. Now, an officer, if that officer had been somebody, he wasn't, but if that officer had been somebody who had a history of failing to look inside the patrol car before he takes it on a patrol, that line of cross-examination could have been hugely beneficial to the defense, right? Because now you have a situation where maybe that little jar of cocaine actually had been there from some prior arrestee, and it didn't actually belong to the defendant who was on trial. So that's just one example of where something that seems really minor could actually be material in a case. So like Ashley and Matt were saying, why not just have it on your list, your disclosure list, and then actually give that information to the defense. So another recommendation I just wanted to flag for everybody as part of our guide is it is important to have an appeals process in place so that police officers can essentially challenge their designation on the list. From what I heard from various DA's offices, this appeals process, when they're implemented, they're not used very often, but I think it's just important substantively so that police officers have a way to get off the list if they shouldn't be. I know in one office we spoke to, there was an officer who was mistakenly put on the list. So just the fact that they had a proper appeals place was important so that that officer could quickly get off the list. But then also it sort of fosters a level of cooperation and buy-in from the police that you might not otherwise have. So if a police department learns that you're creating this Brady list, sometimes there might be pushback from the police department, concern that now you're going to have officers who are blacklisted. But if you can sort of say, listen, we're going to have an appeals process in place so that if for whatever reason officers think they should be on that list, there is going to be a formal way to get off of it. Another recommendation that we have in the guide is it's not just about what is disclosed to the defense, but different offices have different levels of access to the list for their line prosecutors. So, in Maricopa County, for instance, in Arizona, prosecutors can learn whether or not someone's on the list as soon as the case is opened or transferred to them. So very early on. Some offices will only notify the line prosecutors once that person is notified to testify for trial, which is obvious, or not for trial, excuse me, to come to court, even if it's just for trial prep. But our recommendation is it is better for not just the defense, but for the prosecutors to learn as early as they can whether or not their case has somebody who's on the police disclosure list. Once they can disclose it earlier, but also so that they're aware of, like I said before the beginning, the quality of the evidence in their case. One thing we recommend, and of course this only really applies to the elected DAs and not necessarily the prosecutors on this call, but to the extent you can, to advocate that your office support efforts to make substantiated claims of police misconduct more accessible to the public. There are a lot of reasons why prosecutors' offices are not making these lists public. Some of it is their concern, rightfully so, that they might get sued by police departments for violating privacy laws that protect police disciplinary records. Some of them are concerned that they're going to lose the cooperation of the police department in getting this information. So, that those memorandums of understanding that they might have created about sharing information might be rescinded if the list is now just made public. And then a couple of DAs who we spoke to just said, that's really not within the purview of the prosecutor to make this information public. That's something that should really be deferred to the legislature. So there are reasons not to just put all these lists on the internet for the whole world to see. But that being said, to the prosecutors can foster more trust and accountability within their system if they're at least advocating for legislative efforts to make this information more publicly available. There's one, just get out of this here. There's one office policy I wanted to share with everybody. Do we have anybody from Bernalillo County, New Mexico on the call? Okay, so this is Bernalillo County's website. And what they have done is they have sort of made their list public. They have the name of the officer and the case number and date. And if you click on the case number, they provide a letter that says, it doesn't have any information about the nature of the police misconduct, but it'll just basically say to defense attorney, you should know that there's potential information, impeachment material on officer so-and-so. And this sort of allows the defense attorney to then get that information. But interestingly, this is available to the public. And the idea was essentially the office didn't want to run afoul of police privacy laws, but wanted to be as transparent as they could. So this was sort of the compromise that the office came up with. So just sort of an interesting way to sort of balance the two interests, namely, the privacy interests of the officer and not, running afoul of any statutes, but also trying to promote some level of transparency and accountability to the public. The last thing I want to say, and then I'll turn to Q&A, is the idea that prosecutors would really benefit, in our view, from having more access to the lists of other offices. We'll get to the Arizona Prosecuting Attorneys Advisory Council database in a second. But I had a video for you, which I'm just going to drop it in the chat, just in the interest of time, and everyone can sort of watch it on their own later. But there's a story about a police officer in Fairfax County who was essentially terminated, or at least disciplined, and for misconduct. He then went to a different office, a different police department in Florida. And through some kind of administrative error, when Florida asked Fairfax County, sort of like a background check, is there any reason for us not to hire this police officer here in Florida? Fairfax said, no, this officer is, an officer in good standing. And so, police, there's all kinds of gaps and holes in police departments sharing information about misconduct with other jurisdictions. And so prosecutors can try to fill that void, in our view, by sharing information. Now, again, you might not be able to just make all this information public, but just as an interesting example, sort of in response to this problem of officers moving from one jurisdiction to another, the State Prosecutors Association in Arizona last year, they launched a public database. And I'll just sort of show you what that database looks like. And it's on the APAC's website. If you were to look up the name of an officer, you could click on that officer's name. Here, I'll do this again. So I just put John Smith as an example. So you have Jane Reith. And when you click on Jane's name, for some reason, of course, it's not working now. But when you click on the name, it doesn't have anything about the allegation. It has the name of the agency that they worked for, and the prosecuting office that has information about that officer, but there's no detailed information about what the misconduct was. And so now if you're in County A in Arizona and you find out that, Officer John Smith had some misconduct in County B, you can at least call County B and find out what that information was. So let me see here. Let's see. And the last recommendation I just want to highlight, because I think this is something that concerns a lot of prosecutors' offices, is, engage with your local police department about the police disclosure list before you're going to implement the policy. So in other words, don't just create a Brady list, put it out there for the public, put out a press release, and then start adding to this list and using it as a disclosure mechanism. Meet with your police department first. There was one county that we spoke to in which representatives from that office met with police agencies in that jurisdiction and basically tried to address their concerns, told them why that they were putting this list together. It didn't necessarily mean that the police department was now happy that this list was being created, but it obviously gave them a chance to voice their concerns, gave the DA's office a chance to maybe implement some changes to their policy based on the concerns they had. And then to the extent that they weren't going to accommodate any police requests for changes in the policy, at least explain why, rather than just sort of forcing this new policy without any engagement with the police department. And the DAs from that office basically said that there was more cooperation from police departments as a result of those meetings than if they had just put this policy out there without any conversations. So I know I was talking fast. but it's because we only got about an hour. And I thought I would give anybody a chance to react or Q&A if you have any, but wanted to thank you for sitting through. I don't know, mid-afternoon is hard for me personally, so I don't know if anyone else here needs an extra cup of coffee, but happy to field any questions that you all might have.
Great. And thank you so much, Alyssa. So I'm just going to launch the poll for post-meeting evaluation now for folks and ask that you please fill that out before you leave the meeting. But while we're here, if folks have questions or pushback or comments for Alyssa, please feel free to just unmute and go ahead and participate from here.
Oh, well, I was going to ask Alyssa, thank you so much for your talk, and just more on strategies to get police departments, more involved. Besides, just meeting with them and giving them a heads up, about the policy. Are there any points made that were particularly powerful in getting police departments to be more cooperative, about why
the honest answer is no. I mean, I think, one thing I would recommend, of course, is, don't meet with them 2 days before you're about to announce this policy. I think the ideal is to meet with the police department, maybe even early on in the process, and say, listen, we have a legal obligation to turn this over to the defense. We also think it's the right thing, but personally, putting aside what we think is the right thing, we have an obligation by law to do this. And so we'd really like to work with you to make this happen. We want to do it in a very, in a way that's efficient and is streamlined and doesn't just add an unnecessary bureaucratic burden on you, in terms of getting the disciplinary records from the police to the prosecutor's office. So would just love to hear, your thoughts on how we can make that happen. Now, this all depends, of course, on the DA's relationship with the police chief. Some of the DAs who we work with have great relationships with the police chief. In Bernalillo County, Raul Torres and one of his local police chiefs have a great relationship, and the police chief who was on board with this whole concept. Now, I realize that that's not going to be true in every jurisdiction. But even where it's not the case, reaching out and having them give input early on, I think will go a long way. Again, it doesn't mean that the police chiefs and the police departments, and certainly not the police unions, are going to be necessarily happy about this new policy. But to the extent that you can engage with them early and not just have one meeting, I think have several meetings to get as much buy-in as you can before you implement the policy and then announce it to the community at large, or some of the things that came through to us through some of those conversations. But thanks for your question. Hopefully it answers to some extent. Yes.
All right, question from Iowa. So our legislature is considering a statewide database or panel to track disclosures. And most of our counties are small and rural, and they might only have one prosecutor. And we had someone testify that he doesn't have to write it down because it's just all in his head. He knows whether his officers have a credibility problem. Any ideas from an Innocence Project point of view, where we're trying to shape the reform and provide input on other things that we could give the legislative committee to help them?
You mean in light of the fact that this prosecutor is not going to be helpful in the process? I mean, number one, in response to that, we don't know if that elected DA. I mean, this is a little dramatic, and I'm being facetious a little bit, but he could get hit by a bus tomorrow, and then what happens to all that information? Right. Or he could retire, or he could get voted out of office, and then a transition is going to involve all kinds of things other than, I have to now conduct a brain dump of everything I know about every officer. So completely agree with you that that's not going to work. Just have it all in the head of one person, or even frankly the institutional knowledge of every prosecutor in a small office. I mean, I think in terms of what you can provide to this, did you say it was a task force or something like that?
It was a study committee.
Yeah, I mean, I think sort of explaining why this cases are going to, I think, more often get thrown out for failure to comply with Brady. It happened, like I said, the Deborah Milkey case, I think, is a really dramatic example of that. But I think especially the more you have offices creating these lists, the more it's going to become expected and common practice. And, you know, from the prosecutor's standpoint, even the prosecutor who you're mentioning now, you know, number one, nobody wants to be responsible for a wrongful conviction, but also nobody wants to have a conviction that they're convinced is otherwise solid thrown out because the line prosecutor didn't comply with the basic principle of Brady. So if the whole, well, we don't want to wrongfully convict people argument doesn't seem to hold much sway where you are, I think the other argument, which is equally valid and problematic for prosecutors, is you might have a really, you know, good conviction, so to speak, that you want to stand, but you don't want to risk having it tossed or having to retry a case from 20 years ago because your line prosecutors didn't have access to that information and then therefore didn't disclose it to the defense.
Thank you.
Sure.
Thanks, Erica. Other folks in the last couple minutes that we have, Alyssa, before she needs to leave. Looking through. Okay. So I want to say, Alyssa, thank you so much for joining us today. This is incredibly helpful information. I'm going to go ahead and put that the information about the report itself, along with the appendix that Alyssa was mentioning here in the chat, if anybody didn't see it earlier. So there it is. As always, folks, thanks so much for joining us. We want to make sure, and Alyssa has put her contact information in the chat as well.
Yeah.
So if you have questions about it, I'm sure please feel free to reach out to Alyssa. Right?
Yes, definitely. Yes, thank you so much for having me. Thanks for sticking with us and for your questions. And then if anybody wants to talk online about anything related to this or any of IIP's other initiatives, you know, our website is there and would love to hear from you individually by email too.
And the resources are absolutely terrific. They're very thoughtful, well thought through, and doable, which is probably one of the more important aspects of this kind of work. So, Alyssa, thank you so much for your time. Everyone else, again, I apologize for all the emails today. Hopefully we'll fix that for next month. And looking at you, Craig, if you are still here, Craig McElwain, his folks from Suffolk County will be with us next month to talk about a terrific report that they just submitted just this past month of an audit of cases, and then again in February. So we don't hear from everybody. Happy holidays. Hope everybody has a restful holiday season, and we will see you in January. Thank you.
Thank you. Bye, everybody.